Today, we're discussing a case that was recently heard at the Supreme Court of Canada, a case that the charity I work for, the Canadian Constitution Foundation, intervened in. The case is about the constitutionality of a law called the Impact Assessment Act. The law established what's called an impact assessment agency, and this allowed Ottawa to evaluate major projects like pipelines, mines, and interprovincial highways based on a wide range of environmental and social issues. Many people have called this the No More Pipelines law because the law means it's extremely unlikely that new pipelines will be built in Canada. The law lengthens and complicates the regulatory process, it increases the risk of litigation, and is a significant barrier to new investment in Canada. The law was challenged by the Alberta government, and the Alberta Court of Appeal found that the law was unconstitutional because it treaded unjustifiably the federal government into provincial jurisdiction. What can we expect now that the Supreme Court has heard this case? Here to explain is the lawyer that represented the CCF at the Supreme Court, Brett Carlson of Borden Ladner Gervais. Brett, thanks so much for joining me today. Let's start by explaining what the Impact Assessment Act is. I outlined it a little bit briefly at the top, but it's a complex piece of legislation. What do you think viewers need to know about it?
Thanks, Christine, and thanks for having me on today. The Impact Assessment Act is really one of the Liberal government's flagship environmental policies. It was introduced in 2019 in response to the somewhat controversial amendments that were made under the previous government in 2012, known as CIA 2012. So, at its core, the Impact Assessment Act is a cradle to grave environmental regulatory assessment process. It designates projects, and once designated, it subjects them to a hold while the federal government decides, by looking at various factors, whether or not that project is to proceed in the public interest.
So, what are the types of projects that this law applies to? I mentioned things like pipelines, interprovincial highways, mines, but could it apply to something wholly within the province of Alberta? If it was just in Alberta or if it was just in Saskatchewan, could the federal government say, no, that development is not allowed to take place, even though it's not crossing any provincial boundaries?
Certainly, and in fact, it's not whether it could, it already does. So the designated project list, or the physical activities regulations is what it's called, it already lists a set of projects and activities, dozens and dozens of them, that the act applies to. So some of them are clearly within federal jurisdiction. You have interprovincial works and undertakings, such as transmission lines and pipelines, or coastal works, things that you typically expect to be federal. But then it has a whole list of projects that seemingly are contained wholly within the boundary of one province. So, as you said before, that includes roads. So, the construction of a new highway that is more than 75 kilometers in right of way. You have the construction
Even
operation.
all within one province.
Certainly, yeah. So it doesn't seem to make an effort to distinguish between those two. And the trigger that it uses, and this is a critical part of the act, the trigger that it uses to subject activities under the act is based on a definition of what's called effects within federal jurisdiction. And Canada uses that to argue that, well, all of these projects are in fact within federal jurisdiction. And as we can talk about further, it's really a thin basis in which they're arguing that these effects are in fact within federal jurisdiction, and many of them in fact aren't. So wide range of projects, thin relationship to federal jurisdiction, and you end up, invariably capturing what would typically be provincial projects.
Yeah. So what's important for viewers to understand is that the Constitution, or Canada's Constitution, defines areas of federal jurisdiction and provincial jurisdiction. So the federal government can claim we're only legislating here or regulating here as it affects areas of federal jurisdiction. But what you're saying is that perhaps they're actually treading into provincial jurisdiction. Is that the problem here with the law?
Yeah, so just for a bit of background, the Constitution assigns to the provinces and to the federal government certain areas of exclusive jurisdiction.